Hello friends, welcome to our channel Legal Nexus. Today we are going to discuss about vicarious liability. Vicarious liability in tort law is the concept where one person is held responsible for the tortious act of another based on a specific relationship between them. Essentially, it means that even if someone didn't directly commit a wrong, they can still liable for the damages caused by someone else's action. This most commonly apply employer-employees relationship, where the employer is liable for the torts of their employees committed within the scope of their employment. A master is liable for the wrong done by his servant in course of his employment. This is known as the doctrine of vicarious liability, basic principle of master's liability. There are two principles involved in making the masters liable for the acts of the servant. Cui facit per alium, facit per se, respondent superior. Qui facit per alium per se is a legal maxim meaning he who acts through another does the act himself. It is essential establishment that a person is liable for the action of someone they have authorized to act on behalf. The master's responsibility for the servant's act had also its origin in this principle. In such a case, the person authorizing is liable not only for the act actually authorized but also for its direct consequences. Respondent superior is a legal doctrine that holds an employer liable for the actions of their employees or agents performed within the scope of their employment. It is essentially means let the master answer. It means let the principal be liable all acts done by the servant in the master's business are deemed to be the acts done by the master himself. Since the master is rich and capable of bearing the civil liability and paying compensation, he is made liable for the all activities of the poor servant who is financially weak and cannot pay the compensation to the injured party. Essential condition for master's liability. Any of the following conditions and rules are complied with, the master is liable for the acts of his servant. Otherwise, the master is not liable. Firstly, the relationship of master and servant should exist between the defendant and the actual wrongdoer. Secondly, the tort must be committed by the servant while he was engaged in the course of employment of the master. Thirdly, the master is not liable for the tort of an independent contractor. Rules of master's liability. Natural consequences of an act by the servant. There must be want of care or negligence on the part of servant, excessive or mistaken act by the servant, willful wrong, fraudulent act or criminal act by the servant working under two masters. These were the rules related to master's liability. Next, we are going to discuss about the important case laws related to vicarious liability. Gregory versus Pipper. There was a dispute as to the right of pathway between Gregory and Pipper. To stop Gregory, Pipper ordered his servant to heap rubbish. The rubbish slid down to the Gregory's property. Gregory sued Pipper for trespass. It was held that the master was liable for the acts of his servant. William versus Jones. Jones employed a carpenter to make a signboard in the shed of Williams. The carpenter, in lighting his cigarette pipe, negligently threw the match on the floor and that set fire to the shed. It was held that the master was not liable because negligence was not in making the signboard, which the master's business, but negligence was in smoking the pipe, which is the servant's habits. Because of that, he is not liable. Master's non-liabilities. In the following three cases, the master is not liable for the tort committed by his servant. Firstly, when the master has temporarily lent his servant to another person, then the master is not liable for the tort committed by his